A warm welcome to everyone, and thank you for joining us today for our workshop on the topic Ravens and Rivers, Debating the Rights of Animals and Nature. My name is Raffael Fasel, and I am the Executive Director of the Cambridge Centre for Animal Rights Law. This workshop is the first in a series of online workshops that the Cambridge Centre will be organising this academic year, and in which we will explore the relationship between animal rights and cognate approaches and disciplines. Before saying a few introductory words about today's workshop, I would like to briefly explain the format of the event. We are using Zoom webinar, which allows all our attendees to listen to the fascinating presentations we will be hearing and seeing from our speakers, without having to share video or audio themselves. Members of the audience will, however, still be able to interact with our speakers in the last part of the workshop, which is specifically dedicated to discussion and to answering any questions you might have. You will be able to ask your questions using the Q&A function. When asking a question, please indicate your name, affiliation, and location first. The chat function, on the other hand, will be largely disabled and will only be used by me to communicate information to participants. Please also note that we are recording this event and will later be uploading it to our website. In order not to inhibit debate, we will, however, not include the discussion Q&A part at the end of the workshop in our recording. Now, with this out of the way, let me now turn to the topic of today's workshop, the rights of animals and nature and their relationship. We have invited 5 leading scholars and practitioners in the fields of animal rights and rights of nature to explore with us today what the relationship is between these two approaches to rights. We will be identifying similarities and synergies, but also be looking at potential differences. Our center's aim in bringing experts on animal rights and nature rights together is to enhance understanding of the relevant issues, facilitate discussion, and build bridges between scholars and practitioners. Now, why has our center decided to focus this workshop on the rights of animals and nature in the first place? I will try to answer this question in 3 steps by focusing on the 3 concepts that are prominent in the workshop's title: ravens, rivers, and rights. Let me start with ravens. The primary goal of the Cambridge Centre for Animal Rights Law is to study the fundamental rights of non-human animals, which is why it seemed natural to us to start with other animals. Those of you who have visited Cambridge before will know that many ravens have made Cambridge their home. And those who are students or staff at Cambridge even have a so-called raven password to access their university web services, which are named after the animal. Ravens fascinate many humans when they gather in large roosts, play with others, or display remarkable intelligence, such as when fabricating their own tools. However, as is the case not only in the UK, but also in virtually all other countries, ravens and other non-human animals possess no fundamental legal rights to protect their basic interests. Animal rights philosophers, lawyers, and practitioners have done a lot to explore the anthropocentrism that characterizes current legal systems around the world. And they have illustrated its limitations and shortcomings when it comes to the protection of the fundamental interests of non-human beings. What some of this work has revealed is that laws protect only certain aspects of the welfare of some animals and largely not their fundamental interests in life, integrity, or in living natural lives. As many scholars have noted, there is an often strict dichotomy in place here between humans and their legal status and the rights of non-humans on the other hand. It is a binary concept of inclusion and exclusion. Either you are a member of the club or you are not. On this view, non-human animals are essentially objects on which property can be established by humans. Interestingly, this dichotomy has not always been as strict as it is today. To give an example that fits nicely with our theme today, in Germany in the late Middle Ages, humans could lose all their legal protections and be declared vogelfrei, which literally translates as free as a bird. These humans could be killed with impunity because they had lost all their rights. This phenomenon of outlawry has existed in many legal traditions and goes back at least as far as the law of ancient Rome, where humans could be excluded from legal protections as so-called homo sacer. In the English common law, it was possible to declare humans caput lupinium, literally meaning, let his be a wolf's head. As with the German free as a bird, the idea behind caput lupinium was that, like wolves, these humans were now in a state of rightlessness and could therefore be killed with impunity. In recent times, however, we have seen breaches in the wall separating the excluded from the included that have gone in the other direction, with certain animals being granted admission to the club, as it were. To give just one example, in a decision from 2011, the Gujarat High Court in India ruled that birds, and I quote, have the right to move freely in the open sky, end of quote. This finding was repeated in 2015 by the Delhi High Court, and it is reflected more generally in cases from around the world that discuss animals as potential holders of fundamental rights. These sorts of cases show that the legal status of animals is not set in stone, and that they can become holders of fundamental rights, legal personhood, or legal dignity. Moving animals from being excluded to being included in such legal statuses involves a reorientation away from anthropocentric legalism and toward legal systems that recognize and protect the interests of non-human beings. This brings me to the second guiding concept of today, rivers. While our center is focused on the rights of non-human animals, it would be futile to try to separate these beings from their natural habitats. This is true both practically and conceptually. Practically, it can be extremely detrimental to the physical and mental well-being of animals to remove them from their natural habitats and to place them in artificial environments created by humans. This is illustrated, for example, by the repetitive and often harmful behavior displayed by animals in captivity. And it is often equally detrimental to the habitat itself, in which these animals play important roles. But it is also true conceptually that animals cannot and should not so easily be separated from their natural environments. This is because it will be difficult or even impossible to understand what rights animals such as ravens could have without considering their environments and relationship with such phenomena as rivers or trees or meadows. For example, if rivers were granted a legal right to protection of their physical and mental integrity, as well as to live in their natural habitat, we would have to be aware of their relationship with rivers, trees, and meadows, as well as other animals, to understand their needs requiring rights protection. As our keynote speaker, Cormac Cullinan, has argued in his eye-opening book, Wild Law, current legal systems do not only consider animals as outlaws, but nature more generally. In other words, like animals, nature largely lacks rights protections that can be effectively enforced in courts. It too is not part of the club. Hence, a reorientation of the anthropocentric status quo of legal systems would be the requirement and result not only of animal rights, but also rights of nature approaches, which take an even broader look at the place of human law on Earth. This brings me to the last key concept, rights. There is widespread acceptance that legal tools are required for a move away from legal anthropocentrism. But this creates a paradox. How can we overcome outdated ways of anthropocentric thinking if we rely on anthropocentric concepts such as rights, courts, or legislation? As I understand them, both the animal rights and rights of nature approaches face up to that paradox rather than trying to avoid it. They both have in common the recognition that, albeit limited, the anthropocentric tools are the most effective tools we currently have available, and that it would therefore be better to try to work with and improve these existing tools rather than to operate outside established legal language and concepts. There is recognition, in other words, that law is as powerful an instrument as it is dynamic, and that it not only creates problems for the protection of animals and nature, but also opportunities. The conceptual apparatus it offers is one that can not only be developed, but also repurposed to protect the interests of humans as well as those of non-humans. And the legal arguments developed by animal rights and rights of nature scholars for this purpose are some of the most creative and interesting I have seen. I'm not saying, of course, that there are no other approaches that can and should be pursued by those wanting to promote the rights of nature and animals. But I am saying that the legal rights approach is one particularly promising piece of the puzzle. It is in this light that I read Cormac Cullinan's definition of wild law as an, and I quote, approach to human governance, end of quote. That is, I read it as an approach necessarily conducted by human beings using human tools, but with minds and hearts open to the fact that there is more to the world than Homo sapiens. Now, having relied so much on his work, it is now time and a true pleasure for me to introduce our keynote speaker, Cormac Cullinan. Cormac Cullinan is an environmental lawyer, activist, author, and advocate for ecological sustainability and the rights of nature. He is director of South Africa's oldest specialist environmental and green business law firm, Cullinan and Associates in Cape Town, and also directs the Wild Law Institute. He has been included in a book profiling 301 extraordinary environmentalists in history, and is a recipient of the Nick Steele Award for the South African Environmentalist of the Year, as well as the Enviropedia Ecologic Lifetime Achievement Award. His groundbreaking book, Wild Law, A Manifesto for Earth Justice, which I have mentioned before, pioneered Earth jurisprudence and has played a significant role in informing and inspiring a growing international movement. He also led the drafting of the Universal Declaration of the Rights of Mother Earth, is a founder and executive committee member of the Global Alliance for Rights of Nature, and he is a judge of the International Tribunal on the Rights of Nature. We have the honor of having him with us today and look very much forward to his keynote address entitled The Indivisibility of Ravens and Rivers, Exploring Relationships and Rights. Cormac, the virtual floor is yours.
Thank you very much, Raffael. And it's a pleasure to be here. I'm sorry we're not physically in each other's presence, and we can't see the faces of the audience, but I'm very glad that this is going ahead despite the conditions under which we're working. And I hope that perhaps more people can attend because of this. So the subtitle of this conference is Debating the Rights of Animals in Nature. And I think this is an extremely important conversation. Now, any such debate is inevitably haunted by the ghosts of previous acrimonious exchanges between advocates of animal liberation and environmentalists, and between animal welfare or animal rights advocates and conservationists. As many of you will know, these have often been portrayed as mutually exclusive approaches. Some writers have gone so far as to say that it is impossible to be both an advocate.
Sorry about that. So I had just been saying that inevitably any discussion on these issues is haunted to some extent by the ghosts of previous acrimonious exchanges between advocates of animal liberation and environmentalists, and between animal welfare or rights advocates and conservationists. As many of you will know, these have often been portrayed as mutually exclusive approaches, and some writers have gone so far as to say it is impossible to be both an advocate of animal rights and an environmentalist. Personally, I do not subscribe to this view, and for those of you who may subscribe to it, I hope to persuade you that the ecocentric legal philosophy known as earth jurisprudence, or the rights of nature, and animal rights are mutually supportive, and that the differences are very slight in comparison to the similarities. As somebody once said to me, when we're searching for common ground, we sometimes forget that it's beneath our feet. And I would suggest to you that the commonality between earth jurisprudence and rights of nature and animal rights is earth itself. But I like stories, so let me begin with a story that I was told many years ago about somebody seeking directions in rural Ireland. So apparently a couple going along in a car and they're a bit lost. They're looking for a small village called Kilmallock. And as they drive along, they see an old man, a farmer at the side of the road, and they pull up and they ask him, "Tell me, good man, do you know the way to Kilmallock?" "Oh, yes," he says, yes, I know Kilmallock." So they said, "Please could you tell us, because we're slightly lost." So he said, "Oh, yes, no problem. You go up to the end of the road till you get to the crossroads, and then you go left, and you drive for a few miles, and then you take a second right, and then..." No, that's not right. Sorry. Let me start again. You start from here, you drive up to the crossroads, and you go right. Then you go for a few miles, and you go first left, and then you... No, actually, that's not right. Anyway, this carries on for some time as the old man tries to remember the directions to Kilmallock. And eventually he says to them, "No, I'm sorry. You can't get to there from here." And we find the story funny because we know that even if it's not apparent to the old farmer, you can get to anywhere in the world from where you are now. So let's assume that the equivalent of Kilmallock, the town we want to get to, is a place where animal rights advocates and activists work hand in hand with people in the rights of nature movement in order to transform legal systems in ways that are beneficial to animals and to other beings. So this, if you like, is our desired destination. And I would suggest to you that it's desirable whichever one's starting point is, because both animal rights lawyers and rights of nature lawyers seek to transform the legal system in absolutely fundamental ways. And if one wishes to make big changes, you need a lot of allies. And that is one of the most important reasons why I think it's in all of our interests to try and find our way to this rendezvous where we can work together. However, I'm going to assume that we have an animal rights lawyer on the one hand and a rights of nature lawyer on the other who wish to rendezvous at this place. But of course, they're starting in different places. So I imagine the animal rights lawyer looking up from her computer where she's drafting an urgent injunction, or what we call in South Africa an interdict, to require the city of Cape Town to return a baboon which has been removed from its troop back to its troop. Now, this is actually something which is playing out in Cape Town at the moment. There is a baboon by the name of Kataza that was found to be, the authorities thought was causing trouble and leading raids into people's houses. And so it was captured and removed from its troop and taken somewhere else, and is now wandering around Cape Town rather forlornly. And there are a lot of people who are trying to get it returned. Now, as a good animal rights lawyer, she is writing arguments about Kataza, which emphasize essentially the intelligence of the animal, of how Kataza is an extremely sentient being, not unlike humans, and is suffering great stress and anxiety as a result of the treatment. So, in other words, the starting point of this animal rights lawyer is that this is a being not too dissimilar from human beings, that is worthy of moral consideration and consequently of rights that should be withheld, and is entitled to be returned to a social context in which the social context that the animal had chosen. Now, on the other hand, the other lawyer is a rights of nature lawyer. So let's say she is sitting at her computer drafting an amicus brief to be filed in Ecuador, a country in which the rights of nature are enshrined in the Constitution, in which one could actually argue for the rights of nature in court. The brief that she is drafting is to intervene as a friend of the court in a case which is about whether or not a large mine should be allowed in an incredibly biodiverse forest. This lawyer has never been to that forest, and she's never encountered any of the threatened animals in the forest, but she is fashioning her arguments based on the rights of nature enshrined in Ecuador's constitution, and arguing that the constitutional provisions which recognize the rights of nature require that any human developments must be undertaken in harmony with nature and not at the expense of nature, and may not threaten the existence of a species. Now, what I want to suggest to you is that one of the ways in which these two lawyers, with their different starting points, one focusing on an individual animal and another starting from a much more shall we say, high level or overview position, can rendezvous at the same place. And what I want to suggest to you, that one of the roads that will help them get there is to follow relationships. So let's start with relationships. Now, I was very influenced by the writings of Thomas Berry, who wrote a book with Brian Swim, which known as called The Story of the Universe. In The Story of the Universe, they argue that the universe, the development of the universe, can be characterized by the principles of what they call cosmogenesis. In other words, by looking at the universe around us, we can deduce from that there are certain principles which guided its development. The first one that they identify is differentiation. In other words, there appears to be a tendency in the universe to diversify, and that one just has to look at the diversity we see around us to see that nature has, if you like, a predilection for perhaps starting with one species and diversifying into many, but it applies not only between species, but also ecosystems. The second principle is the principle of autopoiesis. In other words, autopoiesis means really self-making or self-regulation. So this understanding is that aspects of the universe, like an individual organism, have to regulate themselves. So they have the metabolisms and they try and maintain homeostasis, but that level of self-organization also applies at different levels, including at the ecosystem level. The third principle is what they refer to as communion, that despite the differentiation into different entities or beings that self-regulate, all of them are constantly in relationship with one another, the communion. So in a paradoxical way, the greater the degree of differentiation, the more beings there are and more types of beings, the more interrelationships between them and the greater the cohesion of the whole. So in a paradoxical way, differentiation produces more cohesion or communion, if you like. Now, if we take this to be the nature of the universe as far as we can discern it, and I completely accept that our knowledge of the universe will never be complete, and we are using working models, if you like, then if we approach the question of the raven and the river, so the title of the conference juxtaposes the raven and the river. But I want to draw attention to the fact that between the raven and the river, there is an incredibly complex network of relationships. And this allows these relationships flow through innumerable other beings. They may be biota in the gut of the raven. They may be the food that the raven eats, the branch of the tree on which the raven is perched. But this is a network so intricate and so intimate that in a sense, the raven and the river are inseparable. The raven is not something apart from its environment. It's not something apart from the community of life that it forms part of. Like all of us, it is a creature that is nourished directly or indirectly by earth, by the river, the soils, the forests, the insects, and the small creatures of the ecological community to which it belongs. And conversely, the mere fact that ravenkind has come into being and that each raven plays a specific and unique role within the ecological community to which it belongs means that each raven matters to that ecological community. Without ravens, the community of life would be impoverished. It would be less complete. It would be less functional. And so from the perspective of Earth jurisprudence, there are a number of important issues here. The first is that the universe is ordered. We are born into a system of order, whether it's at the level of our solar system, with the Earth orbiting the sun, etc., right down to the functioning of ecosystems or the functioning of our bodies. But the context is critical from an Earth jurisprudence perspective. In other words, the system or the whole, in a sense, comes first, because maintaining the whole is paramount because it provides the context within which each being can thrive. Now, to give you a more practical illustration of what I'm speaking about, if we look at what has happened to wild species in my lifetime, since the 1970s, there's been an absolutely catastrophic decline in the number of wild animals, individual animals, as well as depletions in populations and the diversity. Now, this has been driven to a large extent by habitat loss. There are other causes as well. And increasingly, it's being driven by climate change. So you may have heard, for example, that the rise of a few years ago, rise in average temperatures resulted in a mass die-off of the endangered saiga antelope in Asia because the change in temperature produced a change in their gut biota, the bacteria, and which effectively resulted in them being poisoned. But of course, there are many other examples of species dying because of climate change. Now, the point here is that one cannot protect the right to life or existence of the individual animals in this case without protecting the environment which they depend on. So we humans are the same. We may have a right to life enshrined in the Constitution, but if you live in a dry area and you don't have water, the right to life is meaningless. And if you want to have water, then you need to protect the right of the river to flow, of the forest to exist, of the mountain to exist. In other words, one needs to protect the entire hydrological cycle. So in fact, human rights and animal rights rest upon the rights of the whole to exist and function. But that is not to say that the individual is unimportant. It seems to me that many of the debates between conservationists and animal rights activists has been about whether the individual animal is important or whether the species is important. And it seems to me that the answer must be both, because the species is, in a sense, an abstraction. We group animals together as a species for good reason, and they of course, one of the defining characteristics of a species is that the animals will breed with one another. But the species is embodied in the individual animal. In other words, the species only comes into being in the form of the individual animal. And therefore, it seems to me that it's obviously essential to respect the rights of the individual animal, both for its own right and also as a means of protecting the species. But having pointed to the perhaps very obvious point that everything is interrelated and mutually interdependent, I'd just like to touch on the quality of the relationships, because it seems to me that something that probably everybody involved in either animal rights or rights of nature or both would agree on is the idea of biophilia. In other words, the idea that we are born with some kind, with an affinity or love for other living creatures. And in this regard, I think that this is particularly important, because if we look at relationships between human beings, we characterize those most intimate and close and perhaps productive relationships as loving relationships. That we would see as the highest quality of relationship. And in this regard, I really like the quote from D.H. Lawrence, who said, "Oh, what a catastrophe, what a maiming of love when it was made personal, merely personal feeling. This is what is the matter with us. We are bleeding at the roots because we are cut off from the earth and sun and stars. Love has become a grinning mockery because, poor blossom, we plucked it from its stem on the tree of life and expected it to keep on blooming in our civilized vase on the table." And what I love about this quote is that it brings home to us that this intimacy of relationship, this love, is an enormously powerful force that flows through the universe, and it flows through the relationships between the beings in the universe. And although we experience it in a personal sense, it is a far more significant force for intimacy, and in a certain sense, it is what holds the universe together, or certainly what we would call the living world together. So, having emphasized the importance of rights and the fact that, the importance of relationships, and I think it would be largely common ground between animal rights advocates and rights of nature advocates, let's turn to the question of rights. Now, to me, rights belong in the human realm. In other words, they are an idea which we made up. And when I say we, only some cultures made them up. Many cultures do not have the concept of rights. Now, why did we do it? Well, I think it has a kind of pragmatic reason, is that there are certain relationships which we chose to express in legal terms, using the language, for example, of rights and duties, because they were so important that we wanted to be able to use the machinery of the state or of the society to uphold those rights. So, for example, in my country, parents are under a duty to support their children, and their children have a duty to support their aged parents, so-called reciprocal duty of support. Now, those are recognized in law because society has decided that it's good for society to uphold those relationships. But of course, there are many other aspects of the relationship between a parent and child which would not be codified as rights. Now, as we all know, once rights are defined, they in effect frame relationships in society between people. Landowners have certain rights, etc. And one of the crucial issues, of course, was the creation of property rights, which has been fundamental to so many societies, particularly capitalist societies. Now, property rights were essentially created by defining some beings as holders of rights or potential holders of rights, subjects of rights, and others as objects, as things, which could then be owned. Now, as Raffael mentioned in the beginning, the law has, in the dominant cultures of the world, has defined everything that is not a human being or a juristic person, such as a company, as a thing. In other words, it's an object. And as soon as you do that, you're effectively hardwiring in the kind of relationship that existed between somebody who is a subject and somebody who's defined as an object, a slave. So when we defined some people as slaves or as property, they were incapable of having rights because they were the same as, legally, the same as, say, a desk. It's very easy to see in that situation that if you have a slave owner with all the rights and a slave incapable of having rights, the slave owner will exploit the slave. The system is designed to do that. Now, one of the things that happened to counteract that, of course, was the development of the idea of human rights, and human rights being inherent and inalienable rights, which each human being had simply by virtue of the fact they existed. In other words, even if your government denies that you have those rights, even if your courts deny you have those rights, we say that people have human rights and they can't be taken away. In other words, the source, if you like, is the mere fact that one exists as a human being. Now, this idea has obviously been hugely influential and positive in the development of societies. And over time, social struggles have been waged around the world to widen the class of rights holders. If you like, to widen the circle of compassion, for example, to include women, to include children, to include people from different races, religions, sexual persuasion, etc. Now, although we speak of human rights as inalienable and inherent, in fact, it's a little bit of a stretch because one can't go out into nature and find a right. It's a social construct. But having created that social construct, it seems to both animal rights lawyers and rights of nature's lawyers that there's an illogicality about applying it in a speciesist way. In other words, saying that human rights have it, but every other species which shares the same, broadly speaking, shares the same evolutionary history, does not have those rights. And perhaps the only difference is that rights of nature lawyers would agree with animal rights lawyers that the speciesism is not justified, but would go further in saying you must not extend it just to animal species, you must extend it to all species, and beyond that, all beings. And by being, I'm meaning that which has something which has come into being as part of the Earth community. I'm not as simple as that. So the social struggles, whether it be the abolitionist movements, the civil rights movements, the anti-apartheid movements, the suffragists, etc., they have proved, rights-based struggles have proved to be an effective way of changing society for the better. And it is something here which both animal rights and rights of nature advocates would have in common. So perhaps the one difference here is that much of the animal rights literature that I've read appears to base to ground the idea that animals should have rights on morality, on the idea that animals are worthy of moral consideration because they are sentient or they can suffer, etc. and consequently deserve rights, whereas the rights of nature would more say it's illogical to say that a part of the whole, which is dependent on the existence of the whole, has the right to exist, but the whole doesn't. In other words, it's like saying that the leaf on the tree has the right to exist, but the tree doesn't have the right to exist. And in other words, that if one wants to protect the rights of a member of the Earth community, one must of necessity protect the rights of the whole. And how this plays out in law is often through the idea of personhood. Now, in other words, should the raven or the river be entitled to be recognized as a legal person that is capable of holding rights? And we talk about the idea of juristic personality or legal personality. And there's been a lot of argument about if this isn't being extremely anthropocentric, because obviously a river is not a person and a raven is not a person. But I think that there's a misconception here, in the sense that person here really comes from the Latin persona, meaning mask. So this was a situation where it came from theaters where people would wear masks to signify to the audience what their role was in the drama. So the idea is similar in law, is that one goes into court, one wears a mask of a plaintiff or a defendant, of a landowner or a license holder, etc. But the legal mask, if one likes, denotes the role that one plays in the drama of the court. But if you're not entitled to have a mask at all, in other words, if you're property, then you are merely a prop in the drama and you have no agency and cannot hold any rights. Now, the reason, this is perhaps a slightly technical discussion, but it seems to me that often the difficulties or disagreements between the rights of nature approach and the animal rights approach revolves around the question of are there specific criteria to qualify as a rights holder? For example, people have said to me, I can imagine that a chimpanzee or a gorilla should be recognized as a person in the eyes of the law, and one should be able to go to court and to represent, they should have standing in court and should be entitled to have a lawyer, etc. But if you ask me if a river should have that right or a mountain, to me that seems going too far, because they haven't got consciousness or they haven't got sentience in the same way, they're not capable of suffering, etc. So essentially what behind that argument, I think, is the idea that you have to, there's certain qualifications to enable one to become a rights holder. For example, one should be an animal, or one should have sentience, or whereas rights of nature would accept the mere fact that you're a being is enough. In other words, there's almost no qualification. And I think the difference is that the animal rights advocates tend to argue from a moral perspective that animals are worthy of moral consideration, whereas rights of nature advocates tend to say law and rights are just a device. It's something that we made up. And if we're going to say that humans have rights, then it's logical to extend those same rights to other beings, so that we can use the legal system to balance the interests of these beings. So that the legal system is not just used to balance the competing interests between humans or humans and corporations, but also between humans and other beings. So it seems to me that personally, I think that legal personhood is simply a device which the law can use to make other beings visible in the drama that plays out in the court or in the legal system. I'd like to touch briefly on one other aspect which perhaps distinguishes the two approaches, and that is that Earth jurisprudence has been very influenced by indigenous perspectives. Now, some people will say that rights of nature people are susceptible to sort of noble savage arguments. And I think they completely miss the point, and I don't think that's correct. The value of indigenous cultures and people who've been able to maintain indigenous cultures in a more or less intact form is that they are cultures which lie outside of the monoculture. They are outside of the monoculture of property rights, which sees animals and all beings as objects. And they are enormously informative for people like myself who haven't been brought up in those cultures. For example, they talk about, many cultures talk about the original instructions. Typically, there's some mythical ancestor who received instructions about how to live on Earth, and those instructions invariably involve respecting other beings and taking responsibility. And the understanding is, in essence, is that in order to be a member of the community of life, there are very serious obligations and responsibilities that you must abide by. And the other characteristic is the understanding that, as the Sioux say, all our relations. In other words, it's not only are other animals our kin, but also the mountains and the rocks and the clouds. And another aspect is that everything is imbued with a sacred quality, and that in a sense we are all bound not just by our physical interrelationships and dependencies, for example, for food or energy, but also at a deeper level, and that we are absolutely integral. In other words, we are all part, in a sense, of a spiritual and intangible community as well. But perhaps I simply am not aware of the extent to which similar perspectives may have influenced the rights of animal rights movement. So the commonalities, I think, are very strong. We both agree that anthropocentrism is not the way forward. We both agree that legal systems are part of the problem. If our two lawyers meet up at the rendezvous, they would agree that framing animals as objects or property is problematic. They would agree that animals are beings with inherent rights, and they would agree that speciesism is wrong. The differences are perhaps simply that they start at different points. The one lawyer is starting with the whole, and if you like, with a sort of high-level view of the system as a whole, and then coming down to the individual from that perspective. And the other lawyer, starting with the individual baboon, moves up to the context for that baboon, the troop, and then the environment, and ultimately arrives at the whole from the different direction. Perhaps one difference is that rights of nature tends to emphasize that the interests of the whole must predominate. Animal rights tend to place more emphasis on morality as opposed to a kind of holism. And there are differences around domestic versus wild. I think it's fair to say, as some critics have pointed out, that Earth jurisprudence and rights of nature has not been well developed in relation to domestic animals. And there are many issues still to discuss. For example, from a rights of nature perspective, food chains are a very important part of holding the whole together. So it's really important that some animals eat other animals. But the question, of course, is, do humans have the right to predate on other animals? And what are the acceptable limitations on those rights, on that right, if it exists? So in conclusion, I would like to say that I think it's unhelpful to set up animal rights and rights of nature as a kind of a dichotomy, an either or. I think it's an and both. In other words, from the Earth jurisprudence perspective, human rights are a species-specific subset of animal rights, and animal rights is a subset of Earth rights, or the rights of Mother Earth, in the words of the Universal Declaration of the Rights of Mother Earth. So in many ways, Earth jurisprudence and rights of nature merely provide the context, a wider context for animal rights, as opposed to being against it. But I think it's really important that we work together, because, as one writer has pointed out, an advancement in of either theory in a court or legislature will also be an advancement of the other. In other words, every recognition that an animal is a being with legally protected rights is a victory not just for animal rights, but also for the rights of Mother Earth. And all of us are concerned with achieving practical action that will make a real difference on the ground and help improve the conditions under which animals and other beings exist. So I think it's really important that we work together. And in conclusion, I'm reminded of the saying by the Maori tribe that live on the Whanganui River in New Zealand. This river New Zealand has passed legislation which recognizes that the river is a legal person. And it's done so in recognition, in essence, of the cosmology, the worldview of the Maori people who've always lived along that river for a very, very long time. And one of their sayings is, "I am the river and the river is me." And that can be dismissed as perhaps a romantic statement. But as I've said before, in essence, the river and the raven are inseparable, and we too are part of that interconnected web of life. And so if we take the view that I am the raven and the river and they are me, then we ought to join forces, because we are all part of nature attempting to heal herself against the terrible predations and destructions which our incorrect theories of the universe have led us to wreak upon the earth. Thank you.
Thank you very much, Cormac. I'm sure you can imagine all the virtual applause that you're getting now. I'm afraid we can't really simulate it here. But thanks a lot for such a rich presentation and very thought-provoking presentation that I'm sure will give us lots to talk about in the final part of the workshop, in our debate and Q&A session, when the audience and other panelists have a chance to sort of talk with you about some of these ideas that you've mentioned. We now have, however, the chance to listen to our second speaker for today. And this is Cameron Follette, who is an independent scholar and writer. Cameron, she lead authored the book called Sustainability and the Rights of Nature, an Introduction, in 2017. In 2019, she was the lead editor of a book volume about rights of nature entitled Sustainability and the Rights of Nature in Practice, which contains lots of contributions from scholars from all around the world. In addition to her scholarly work, Cameron runs a conservation organization dedicated to protecting the coast of Oregon. And this is also where she is joining us from today at an ungodly hour of the morning, I believe. We are all the more grateful for having her with us today and for being able to listen to her presentation with the title, Rights of Nature in the USA and the Western Tradition. Cameron, the floor is yours. You can now share your presentation if you like.
Okay, I'm going to start with sharing the screen. Hopefully that will work. So people don't have to watch me, but they can look at pictures of other things. Let me see here. Is that right?
It's not sharing anything yet.
Not sharing anything yet. I don't know how to make it. So it's sharing on my screen, and now I can't get it off. How do I get it off? Oh, there we go. Okay. Is it sharing now?
Not yet. Perhaps if you go to Zoom and click share screen, you should see the PowerPoint as one of your options.
I thought I did that, but let me see here. Open link. Okay. Okay, so Let's try that one more time.
Mhm.
There we go. Is that showing?
Yeah, it's working now. If you like, you can hit the presentation button. That way we have a full screen view. Perfect.
Okay. Technical difficulties. I'm going to talk today about first giving an overview of the idea of a living Earth, which is, as Cormac so eloquently said, in some way has to underlie the concept of rights of nature. It's been often stated in the last century or so that the Western tradition doesn't have a concept of living nature in any way, and that's clearly inaccurate. It has come to seem that way as a result of the rise of industrial capitalism, but it is in fact inaccurate, and I want to discuss that a little bit in the briefest possible way before going on to the specifics of the way rights of nature is currently being considered and fought over in the United States. I want to make the initial statement that the term rights of nature sounds excessively legalistic, but it's really shorthand for the idea of making an enforceable legal framework for stabilizing relationship with nature or a unit of nature. As Cormac said, the underlying idea here is always relationship. And that can be with something as splendid and well known in the United States as the Grand Canyon of Arizona. I grew up in that state, by the way, and the first time I saw the Grand Canyon in person when I was 13, I realized immediately that it was obviously a part of nature with whom one has a relationship. There's no other way to describe that particular place. So the current industrial commercial paradigm that has afflicted the Western tradition so deeply is not the norm in the West. It's of recent vintage of the last couple hundred years. There are earlier worldviews of nature and its sacredness and its livingness, to coin a word, which were based on relationship, reverence, and local knowledge. Perhaps one of the most famous is the animal drawings in the magnificent caves of Western Europe of prehistoric art. This one showing a bison. This one is a stag. And the way that people thought in that time is lost to us, but it was clearly an indigenous way of thinking of the indigenous peoples of Europe. In ancient Greece, much later than the early Paleolithic, there was a very strong aspect of ancient Greek religion was the worship of deities of springs, rivers, watersheds, and streams. The earliest mention of nymphs is in the Iliad and the Odyssey, praising their sacredness and their beauty. The earliest evidence of offerings to nymphs in inscribed stones and altars is in the 6th and 7th centuries BCE. Nymph worship in ancient Greece was at its height in the 5th and 4th centuries. To leap swiftly across Europe, the Anglo-Saxon, early Anglo-Saxon and Germanic cultures, from the surviving literature, we can tell that they had what it would be broadly referred to as a shamanic worldview. We know this especially from the famous saga Beowulf, which was written in Christian times, but filled with a pre-Christian worldview. Basically, Beowulf is an initiation tale based on reverence for the bear, the king animal of the north. The fundamental structure of Beowulf, and if you haven't read it, I recommend it to you. It's a wonderful, rich tale. It has to be translated into modern English because it's written in very ancient English, which is almost impossible to understand unless you're a scholar in it. But the fundamental framework of Beowulf is a shamanic journey of descent to the underworld and return in triumph with wisdom for the people. And that's a commonplace in shamanic worldviews, which the Western tradition shared, like all indigenous cultures do. Another aspect of the reverential tradition, let's call it, in the West is traditional ecological knowledge, which is common to, shared by all indigenous cultures worldwide. That's a rich and deep topic, which I can just barely touch on here. One of the aspects of which is so-called transhumance, the taking of livestock to summer pasturage, which was common in various places in Western Europe. This particular picture is of transhumance in Germany. Another aspect of the reverential tradition in the West is Irish, Scottish, and Welsh literature and poetry. There's frequently a pre-modern outlook captured by folklore collections as well. Scotland especially shines in that department. This is a photo of John Gregerson Campbell, who lived from 1836 to 1891. He was a Scottish folklorist and free church minister of Call and Tyree parishes in Argyll, Scotland. He was an avid collector of traditional stories, known for transcribing the legends precisely as the narrators dictated. He didn't take liberties of his own, so we have a good snapshot of the on-the-ground reverential belief systems of people in his area. Another man who gave us a great deal of that kind of information from the past is Alexander Carmichael, pictured here from 1832 to 1912. Born on the Isle of Lismore off the Scottish coast, he had a career as an exciseman in the Scottish Islands, which gave him the opportunity to collect folklore and incantations and prayers from the outer islands, best known for the 4-volume compendium of Carmina Gadelica, which is a compendium of prayers and incantations from the people of the Isles. The other thing I really want to stress here is that the Western European tradition has, and at one point created, an entire society based solely on the responsibilities of relationship. And that is the feudal era of the High Middle Ages from about 1000 CE to 1450 CE. In the feudal Middle Ages, society was shaped on a hierarchy of relationships from the king to the lowest tenant. Each had detailed responsibilities to the one above and the one below, cemented by the act of homage, shown here. One's responsibilities differed based on social standing. Knights had a military obligation, peasants had an agricultural obligation, and to the level above them, and so on. Now, we do not, of course, now live in a feudal society, but the point here is the feudal responsibilities were human-oriented only. However, organizing society on relationship could be easily expanded. The West has a template already in place from the feudal era of how we might organize society based on relationship with other humans, but also units of nature and animals. It's always easier for a society to move in a certain direction if it has some experience, some template from the past, and the West does have a long-standing and rich tradition from which to work. Now we get to the difficult part of the Western tradition, which is how to maintain an idea of relationship and sacredness in one's worldview during the industrial era. One of the primary means, places where that was kept and maintained was via poetry. 18th century poets often focused on respect for nature, such as Alexander Pope. During the early industrialization period, it was the Romantic poets, that is Wordsworth, Shelley, Coleridge, pictured here, who maintained the ideal of the sacredness of nature. The sort of grand old man of poetry in the Romantic era was William Wordsworth, who, among many other things, said, "Poetry is the first and last of all knowledge." And the Romantic poets focused a great deal on ideals of sacredness of nature. And he and they together bequeathed this living nature ideal to later generations. Another method by which the West has protected and preserved the ideal of a living and sacred nature is via film. Romanian scholar Eugene Cadaru has recently surveyed modern films from the 1960s with the idea in mind of looking at where ideals of a living nature come into play. There's a strong focus on talking intelligent animals in children's cartoons and stories. This here is a picture of Bugs Bunny, which is a very popular cartoon in the United States. I grew up with Bugs Bunny personally, and probably many other people did. Another one that I don't have a picture of is Rocky and Bullwinkle, which featured a moose, Bullwinkle. There's also a strong theme of nature's beauty and intelligence in adult artistic films, whether fantasy or not. Solaris, a 1972 film, Avatar, pictured here, which was the best-selling film of 2010 in the United States, and The Lord of the Rings, which is based on J.R.R. Tolkien's massive work. Another place where the West has protected ideals of sacredness and living nature is in so-called fantasy literature, beginning with J.R.R. Tolkien and his work, The Lord of the Rings. The fantasy genre has greatly exploded. A frequent theme is exploring respect for nature and how to live mythically and sustainably in a living world. It's a treasure trove of ideals and understanding of the mysterious world of relationships of which we are a part. Another place that you see a strong keeping hold of the understanding that we are a part of nature and we learn from it as well as take from it, and it learns from us perhaps, we hope, is folk healing traditions. These are very strong in parts of the United States. This is a book about Appalachian folk curing and conjure traditions. Folk healing traditions in the United States are a mixture of European tradition, Christian folk theology, local knowledge of herbs, and local native knowledge. Two of the largest, strongest, and best known ones are the one from Appalachia, pictured here, and the Pennsylvania Dutch tradition. So after that extremely brief excursus into the idea of the sacredness and relationship with nature in the Western tradition, I want to move specifically to rights of nature in the United States. The United States is not a leader in rights of nature by any manner of means, but it's a large country and an important one internationally. And so what happens in the United States via rights of nature is going to influence a lot of other places. The origin of the concept of legal rights of nature came from the United States, from a lawsuit in 1972 called Sierra Club versus Morton. The Disney Corporation wanted to build a ski resort in Mineral King Valley, pictured here, complete with all kinds of different, hotels and recreational opportunities. The Sierra Club Legal Defense Fund sued to stop it and was rebuffed because they could not show they had enough injury, that their members would have enough injury to provide standing to allow them to go ahead with the lawsuit. A law professor at the University of Southern California Law School named Christopher Stone authored a law review article arguing that natural areas and objects should have legal rights, that the legal rights question was not one of standing for human beings, but for the area that was going to be impacted. The case went to the United States Supreme Court, where the Sierra Club lost. However, the Justice William O. Douglas, who was at that point a major figure on the Supreme Court, dissented from the majority opinion, and he said, quite famously now, contemporary public concern for protecting nature's ecological equilibrium should lead to the conferral of standing upon environmental objects to sue for their own protection and or their own preservation. that both Christopher Stone's law review article, Should Trees Have Standing, and Justice Douglas's statement in his dissent became the cornerstone of rights of nature theorizing, analysis, and future efforts. Mineral King Valley, everybody will be happy to know, is now part of Sequoia National Park, and so is permanently protected. The reaction in 1972 to Justice Douglas's idea was incredulity and ridicule. And if I had time, I could read a very hilarious piece of doggerel that was written to ridicule it at the time. Now, there are rights of nature pieces in place in the United States, just not a general framework. For example, we have the Endangered Species Act and similar statutes, which creates guardianship where an agency or a nonprofit can sue for the benefit of an injured species or ecosystem. There's been a great deal of controversy and lawsuits over bald eagles because of their susceptibility, for example, to pesticides. They were on the endangered species list and were protected and have now recovered. There's also the Superfund law, which is the short term for the Comprehensive Environmental Response Compensation and Liability Act of 1980, which sets up a means to assess damages, assign responsibility, and provide recovery for a devastated ecosystem. It taxes chemical and petroleum industries to establish a trust fund to clean up hazardous waste sites when no responsible party is identified. This picture shows Love Canal, which is a very notorious Superfund site at Niagara Falls, where a subdivision was built on top of a toxic waste dump. And the houses started having disgusting oozes into their basements, and eventually all the people were moved out and the houses were shuttered. Third, there's the public trust doctrine, which protects natural resources for the health and well-being of present and future generations. The problem with the public trust doctrine is it's based on human needs rather than ecosystem needs. So it has limitations because of that. What's lacking in the United States? A comprehensive federal constitutionally mandated system of nature's rights, not based on human rights. It needs then also state constitutional language and local implementing laws, and clear statutory language delineating harm to nature and restoration requirements with a legal framework to determine damages. Without that, it won't be possible for a rights of nature system to flourish in the United States. So let's talk about what constitutes rights of nature in the US by another name. Landscape scale restoration is one way in which rights of nature, not by that name, is actually happening in practice. One of the best examples in the United States is this organization, American Prairie Reserve in Montana. They aim to create the largest protected and restored area of 3 million acres in the United States. Founded in 2001, as of 2019, it had purchased 104,000 acres of private lands, leased another 315,000 acres, all clustered around other public lands like Charles Russell National Wildlife Refuge. And they're focusing on the prairie ecosystem. Let's see here. And restoring its keystone species like bison, which is the keystone species of the prairie. Another aspect of rights of nature, essentially in practice, is dam removal and river restoration. The US is the world leader in dam removal and the restoration afterwards to restore rivers to health. This is a change of heart that has been enormous and quite complete. It's one of the most astounding things in the history of the country. In the 20th century, the United States led the world in damming rivers. There were, and still are largely, at least 90,000 dams in the United States. 90,000, over 6 feet tall, plus innumerable smaller ones. But as of 2018, about 1,480 dams have been breached or removed. And now the United States is the world leader in removing dams. The largest removal so far has been in Washington State with removal of 2 dams. This one, Glines Dam, which was, but is no longer, over 200 feet high, and Elwha Dam, which is over 100 feet high, both on the Elwha River. They were removed in 2014, and now the river flows free, and there it is free. After the dams were removed, there were 27 million cubic yards of sediment trapped behind the dams, which all flushed out through the river and out to the Straits of Juan de Fuca. The Elwha's legendary salmon habitats are returning, finally. I want to speak briefly now about local efforts in rights of nature. And this is a tale of two American townships battling the legal hierarchy. Both of them have to do with hydraulic fracturing for shale gas. Both townships are in the state of Pennsylvania. Grant Township was seeking to stop fracking wastewater reinjection well by a Pennsylvania General, what was PGE? Pennsylvania General Energy into the Little Mahoning watershed. They passed a community rights ordinance to ban fracking wastewater and grant rights of nature. Pennsylvania General Energy sued the township. The court ruled that Grant Township had overstepped its boundaries as a municipality. However, the people of Grant Township were persistent folks, and they passed a home rule charter the next year in 2015, including language that natural communities and ecosystems possess the right to exist, flourish, and naturally evolve, and also the right to be free of damaging activities. Then, to the township's surprise, the Pennsylvania Department of Environmental Protection sued the township, which was ironic to say the least. In March of this year, following a higher court opinion, the Department of Environmental Protection actually revoked the permit for the well, which was the first victory that Grant Township had had in 5 years. And it was the first local success of a rights of nature law in the entire United States. The other township, Highland Township, also in Pennsylvania, was seeking to stop Seneca Resources' plan to place a wastewater injection well within half a mile of Crystal Springs, their water source. They did the same thing. Actually, they did it first. They passed a community rights ordinance, which gave the ecosystem the right to exist and flourish, and banned all fossil fuel extraction. Seneca sued, just like in the other township. The local citizens then filed to intervene on behalf of Crystal Springs, and the judge turned it down. But unlike in Grant Township, the people, or at least the local government, decided not to continue fighting. They entered a consent decree removing local obstacles to dumping Seneca's waste. Nevertheless, the local residents passed a home rule charter, just like in Grant Township, which had rights for the local ecosystem. Seneca sued again, and the Pennsylvania Department of Environmental Protection sued this township as they had the other one. The local residents, as in the other case, tried to intervene on behalf of the ecosystem, and the judge said no. However, the local government officials settled the lawsuits, and the Department of Environmental Protection issued a permit for the disposal well. So you can see by this that what actions the local government officials take in the United States is highly important under a local rights of nature ordinance. Here we have a very sad picture of the Follette's watershed in Oregon. Between 2000 and 2013, more than 40% of the watershed was clear-cut, followed by aerial spraying of poisonous pesticides after replanting. The people of Lincoln County passed a community rights aerial spray ban in 2017, the first county in the United States to do so, which included ecosystem rights. The judge in the subsequent lawsuit ruled against granting ecosystem rights, and so that failed. But nevertheless, it was a strong effort at community organizing. It really got people focused. Here is a sad picture of Lake Erie, of the turquoise-ish areas showing the algal blooms. There was another rights of nature fight in the United States besides the ones in Pennsylvania and the one in Oregon, which was for Lake Erie. In 2014, the city of Toledo, Ohio, experienced a huge blue-green algal bloom from agricultural runoff, and warming waters in Lake Erie. They were not allowed to use water from their faucets for 2.5 days. Algal blooms continue in Lake Erie. By 2019, there were 620 square miles of algal bloom in Lake Erie. Toledoans for Safe Water got an initiative on the ballot codifying the rights of Lake Erie to flourish and live, and Toledoans' right to a healthy environment. Over 60% of the voters passed this initiative in February 2019. Immediately, as we would expect, agricultural interests sued. Just as in all the other local rights of nature fights in the United States, local commercial and industrial interests have always immediately sued. The state of Ohio argued that it owned the lake and that Toledoans had no power to protect the lake or those who depend on it. A federal judge in February 2020 struck down the Erie Bill of Rights, and including the rights of nature on federal constitutional grounds. I want to end my little survey here by talking about tribal efforts on rights of nature. Rights of nature is a semi-foreign concept to tribes because their concepts of relationship are more holistic and overarching, and the idea of legal rights for nature, as Cormac mentioned, is a little bit alien, but a lot of tribes in the United States have come to see that rights of nature is an excellent way into changing the industrial paradigm to allow and bring forward the conversation and change the overall paradigm towards a relationship with nature. In the United States, tribes have sovereign status and the right to self-determination. The U.S. has a responsibility to protect tribal resources primarily through the Bureau of Indian Affairs. Unfortunately, the Bureau of Indian Affairs doesn't always see its mission that way. They've approved many mineral leases and other harmful things on tribal lands around the country. So various tribes are trying different ways to incorporate rights of nature in into their own efforts to protect resources. The Ho-Chunk Nation of Wisconsin has decided to do it via the tribal constitution. The General Council decided to place rights of nature in their constitution to protect tribal lands from tar sands and the Enbridge pipeline. The constitution is in the process of all tribal voting. If passed, the Bureau of Indian Affairs must approve it. It's the first tribal nation in the United States to seek to put rights of nature in their tribal constitution. The Ponca Nation of Oklahoma decided to do it differently. They're battling a Phillips 66 refinery and the Keystone Pipeline, which is a long-standing battle for fossil fuels that is, oh, I won't go into it, it's much too long, but it's an enormous long pipeline, which you can see the kinds of damage that it inflicts just to put it in. The Ponca Nation decided in 2018 to grant the Ponca Tribal Court the power to enforce penalties for crimes against nature. Anybody convicted in Ponca Tribal Court of crimes against nature faces up to 1 year in prison and a $5,000 fine for each day of offense. If a corporation commits the crime, the corporation's board chairman is to be held personally responsible. It also establishes a duty and responsibility to not harm all things in nature. It does not create a new governance structure of nature, however. And then the Anishinaabe the Anishinaabe Chippewa tribe of Minnesota, their approach, they tried a third different approach to fuse rights of nature with federal law. The White Earth Band of Chippewa passed a resolution granting the rights of manuman, that is, of wild rice, which is a highly important and traditional food for the Chippewa Nation. And their resolution granting the rights of wild rice in 2019 recognized the rights of manuman to exist, flourish, regenerate, and evolve, as well as to be restored. It places wild rice protection under the Federal Clean Water Act, which is an interesting and novel fusion of indigenous idea, rights of nature, and federal Clean Water Act law. And it also specifies that harm to wildlife triggers maximum fine, the maximum fines allowed under tribal law. In conclusion, so you can see a beautiful picture of the Oregon coast, which in my professional life I work to protect. Will rights of nature survive and flourish in the United States or elsewhere, or just become a pretty word? It's become more and more common for courts and some jurisdictions to place some rights of nature language in their laws or to hand down a case with rights of nature. This is happening more frequently worldwide, also in the United States. But in order to have it be something other than just a pretty word, laws and constitutional provisions guaranteeing humans a healthy environment have to be seen as not enough. In the United States, those laws which guarantee humans a good environment or clean water or clean air are not stopping the degradation of the environment as we know from monitoring. In other words, the permitting system is a failure. The regulatory system that was set up to put some constraints on industrial capitalism is not working. It's been co-opted by the corporations who have everything to gain. What you permit, you promote. In order to flourish in the USA, rights of nature, which would be a major paradigm shift, not merely permitting industrial activity, but a paradigm shift granting rights to the nature that all human beings depend on. It is going to have to, rights of nature language is going to have to be placed at every level of the legal hierarchy. The United States has a hierarchical legal system, starting with the federal government, going to state government, going to county and township government. All levels are going to need to have rights of nature language in place. If that happens, it will also be a paradigm change in our understanding of our place in nature. It's not just a legal system change. It's a change in our understanding of our place in nature, that we are setting up a framework for restraint, honor, reverence, responsibility, and relationship. Thank you.
Great. Thanks so much, Cameron, for this very interesting overview of the different sort of strands of rights of nature protection throughout the West and in the US in particular. Again, I'm sure that's something that we will be able to talk about in our discussion later. We now have 15 minutes time for a break for everyone to get coffees and refreshments. And we look forward to seeing you again here in 15 minutes. Okay, welcome back everyone. I hope every one of you has been able to get a hot drink or a cold drink, depending on where you are right now. This is our workshop, Ravens and Rivers, debating the rights of animals and nature. Before our short break, we have been able to listen to our fascinating keynote speaker, Cormac Cullinan, as well as Cameron Follette, who have been talking about the rights of nature idea from their respective viewpoints. We will now be turning in our next presentation to animal rights. And this presentation is delivered by two experts from Spain. Nuria Menéndez de Llano is a Spanish animal rights lawyer and lobbyist. She is currently pursuing a PhD in animal law at the University of Oviedo in Spain. Nuria is also the director of the Observatorio Justicia y Defensa Animal in Spain and is an associate fellow of the Oxford Center for Animal Ethics. And Nuria is delivering her presentation together with Benito Alaez Corral, who is full professor of constitutional law at the University of Oviedo and a member of the executive board of the Observatorio Justicia y Defensa Animal. They've kindly agreed to give this joint presentation today on the topic constitutionalism and animal rights. Nuria and Benito, you can now share your presentation.
Okay. Okay, can you see the presentation? It's okay?
Yes, we can see the slides fine. Thank you.
Okay. Well, I'm not Benito, as you can see. We are sharing, besides the presentation, also the chair, because I had some technical problems at my desk. Hello, everybody. I would like to start to thanking the Cambridge Center for Animal Rights Law and the Brook Institute for hosting this wonderful webinar. I have to confess that the first time I read the title of the webinar, Ravens and Rivers, I really was very excited because I really love ravens. I find them really smart and fascinating. So I'm afraid it was the perfect excuse for decorate our presentation with many ravens, as you will see. Well, with our panel, we would like to highlight the role of that constitutionalism has in order to consolidate animal rights and to help us to reinforce non-human animals' defense in the legal field. This shared presentation between myself and Professor Alaez will be divided into 3 key sections. I will start introducing briefly the main milestones and the development of the animal rights question, and also the role that constitutionalism could have regarding animal protection. Secondly, both of us will focus on the different legal strategies that constitutional law could use to protect animal rights currently or in the future constitutional reforms. And finally, Professor Alaez will conclude our presentation with some remarks that, in our opinion and in a realistic way, could reinforce political and legal positions to achieve true legal animal rights at constitutional level. As you know, we don't have much time, so I'm afraid we aren't going to be able to dig into the deep suggested matter, but we hope to be able to put on the debate, on the table, the debate of some approaches that could be interesting for a preliminary view. As an introduction, I would like to pay some attention to the animal rights evolution, and then to the role that constitutionalism could play in animal protection. For giving a quick overview of the origin, evolution, and development of the animal rights, we will borrow the animal agency concept to designate the main milestones of the recognition of non-human animals as agents and their consideration from different frames. So for it, we could focus on the moral, the legal, and the political agency of non-human animals. First of all, we have to realize that, in fact, nowadays, we wouldn't be able to talk about animal protection law if previously the animal moral agency had not shed light on the creation of categories as relevant as moral rights, animal moral rights, or animal moral personhood. But secondly, at the same time, we wouldn't be able to consolidate legal animal rights without the previous consideration of animal welfare and animal protection law in the current legal systems. Finally, taking a further step, we will not be able to achieve fundamental basic rights, legal personhood, and constitutional recognition for non-human animals if we cannot reach the proper political animal agency through its settlement on the parliamentary agendas. Now we are going to explore how constitutionalism could be used to improve the animal protection. In the first place, we have to realize that constitutionalism has traditionally played an empowering role regarding humans, that it could be applied and extended to non-human animals, for example, embracing animal protection as a human interest. Secondly, of course, we cannot deny or ignore that constitutional systems have been created by humans and for humans. But even so, the entrenchment that formal constitutional law implies could reinforce the animal protection when it is constitutionalized. In the third place, we will explore three different constitutional approaches to animal protection: indirect constitutional animal protection, direct constitutional animal protection, and the animal citizenship theory. Concerning these three possible constitutional approaches to animal protection and animal rights, I will go on with the first one, what we call indirect constitutional animal protection. And then Professor Alaez will go on exposing the direct constitutional animal protection and the animal legal citizenship approach. So, maybe we could wonder what is what we call indirect constitutional protection of animals. And it has to do with the fact that nowadays, most of constitutions have not animal law provisions. And we can imagine that changing this reality will take time and a very effective political lobby. That's why we find critical searching for legal strategies to constitutionalize indirectly animal interest until they were finally settled in constitutions. And now we will explore straight some of these possible legal strategies. Some of these possible legal strategies could be displayed on three different areas. As you can see, animal protection, activist rights, and legal limits to fundamental animal rights. Concerning to animal protection, we will take into account three constitutional values under which animal protection could be assumed as human interest through three constitutional duties: duty of environmental protection, considering animals as an essential part of the biodiversity; duty of cultural protection, considering animal protection as a part of the culture of the nation; and duty of health protection in a pandemic world, when more than ever it seems clear for us that the connection between animal trade, their consumption, and the global health. Activist rights. The second strategy is the reinforcement of fundamental rights of activists when they are advocating for animals. For example, when they are defending, we can do it defending the free development of personality, the prohibition of discriminations, freedom of demonstration, assembly, or association, freedom of speech, and when we defend freedom of thought, conscience, or religion. Finally, the legal limits to fundamental human rights. This third legal strategy has to do with the possibility of increasing the legal limitations to human fundamental rights that collide with animal interest.
Sorry for interrupting you, Nuria. Can you scroll down a bit? I believe some of us might only see the top half of your slides, or perhaps you could just zoom out a bit, if that's possible. Sorry.
Sorry for that. I will go on then with the third legal strategy, that it has to do with the possibility of increasing legal limitations to human fundamental rights that collide with animal interest. For example, in cases related to freedom of religion, property right, freedom of business, business related to animal exploitation, artistic freedom, freedom of research, and freedom of movement, for example. And now Professor Alaez will go on with the exposing the next approach, the direct constitutional protection of animals. Thank you, and sorry for that.
Okay, thank you, Nuria, for delivering the first part of our speech. Sorry to the audience for the poor showing of our presentation. Let's hope now it works better. As we have right now said, we move on to the second strategy that we have, which is the direct constitutional protection of animals instead of an indirect constitutional protection of animals. This strategy has to do with establishing in constitutional documents animal protection as a state goal. We are thinking, have to say that, about a prescriptive approach, not a just jurisdictional approach to constitutionalization of animal protection. I mean with this that we are only taking into account constitutional documents that establish duties towards animals, but not constitutional documents that regulate competence powers on animal law. That is something that for now is not interesting for this approach. On the same basis, we leave aside Article 13 of the Treaty on the Functioning of the European Union, although it establishes that member states have to treat animals as sentient beings, because its formal constitutional nature is highly controversial, as well among legal scholarship as among, of course, the constitutional courts of the member states. Focusing then on the constitutional documents that establish as a state goal animal protection, we have divided them into three types of documents, depending on how they approach to this establishing of a state goal. The first one could be represented, among others, by Germany, whose Article 20A of the Basic Law of 1949, as established in 2003, established that the state has to protect animals. That was a reaction to the decision of the Federal Constitutional Court of 15 January 2002, that in the case of ritual slaughter banning law, had to grant the right to the claimant, to the citizen, a Muslim butcher, that wanted to be freed from this banning of ritual slaughter, calling the exercise for freedom of religion. As a reaction to this decision of the Constitutional Court of Germany, the Constitution was amended in the sense mentioned, and we now see the consequences of this amendment, for instance, in a decision in 2010 of the same Constitutional Court of 12th of October of 2010 that used this Article 20A as a legal ground to annul a regulation of a federated state on animal protection, because it was not enough protected according to the Constitution. A second strategy of establishing a state goal is getting much more into detail when regulating animal protection in the Constitution. Two good examples of these are the constitutions of Egypt and the Constitution of India. In the first case, Article 45 of the Egyptian Constitution obliges the state and the citizens to give animals a humane treatment, whereas the Indian constitution in Article 51, A, letter G, claims for compassion for living creatures. So specific behaviors that give to animals a certain degree of protection at constitutional level. And the last but not least of the examples that we give to you today is the case of Switzerland, that moves forward one step and together with the duty to protect animals established in Article 80 and Article 120 of the Constitution, asks of governmental bodies and individuals to take into consideration the intrinsic dignity of animals. So it is not that animals are protected because it's a human interest to protect animals, but also because they have an intrinsic dignity that has to be taken into consideration. Maybe some of you could think, or some people could think, that this direct constitutional protection of animals approach as a state goal is lacking of efficacy, is not enough. But let me say that for now, that should not be necessarily like that. I mean, direct constitutional protection as a state goal had at least a triple binding force. First of all, it establishes a state duty that works as a principle and not as a rule. A principle in the sense of Robert Alexi and Ronald Working. It is established as a principle because these avoid bringing constitutional politics to the courts, and so avoids also the so-called counter-majoritarian paradox. On the second side, this state goal of animal protection is a constitutional good or a constitutional value that, as we have seen in the German case, could be used by the courts, in this case by the Constitutional Court, to counterbalance in fundamental rights controversies. And last but not least, the courts can use also as interpretative criterion this state goal as well regarding ordinary legislation as also regarding other constitutional provisions. For instance, to expand or increase the limitations to fundamental rights of humans, as we have seen in the case of the indirect constitutional protection model. But precisely because some people consider this approach, direct constitutional protection, not enough, is why it is also a third approach, or we have also a third approach. The third approach is granting animals as such fundamental rights in the Constitution. And the philosophical background that, in our opinion, is behind this approach is the so-called animal citizenship theory that most of you probably know was developed or is developed by Sue Donaldson and Wilkin Leaker. This theory, as you all know, differentiates or categorizes animals in three types: domesticated animals, as animals that share with us citizenship and have to be considered co-citizens with us; liminal animals that are have to be considered as aliens or foreigners within our societies, and therefore taking the concept of denizenship of Locke, have to be considered denizens; and finally wild animals that live in their own territories, in their own realm, and should be left in that places with their own sovereignty and separated from the human society. Well, having this as background, some jurisdictions, some constitutional jurisdictions have evolved to try to grant animal rights in constitutional text or in constitutional founding sources, particularly in countries of common law, in the case law. Let me say for now that the constitutionalization of fundamental rights of animals in constitutional texts has to be considered yet only a prospective possibility, something that the Constituzione Ferenda could happen, but not something that has been achieved yet. The only example that to my mind is known is the one developed in the city of Basel canton a constitutional amendment bill called Fundamental Rights for Primates, whose legal feasibility has been already confirmed by the Swiss courts, either by the cantonal courts, but also by the federal courts, but with a limitation that, in our opinion, is highly important. The courts have said that nothing obstacles the Basel City Constitution to grant fundamental rights to primates, but those rights stay under federal law. That means that they have to respect and comply with constitutional and ordinary federal law. The consequence is that in, let's say, technical terms, we barely can consider those rights truly fundamental rights, and that constitution a true formal constitution with higher rank. The second possibility is to try to extend or expand through case law human rights such as bodily integrity or freedom of movement to non-human animals. This is a way that has been explored in two parts of the American continent. In the northern part, the Non-Human Rights Project, led by Stephen Wise, has filed in New York 3 different habeas corpus lawsuits with regard to 3 primates, Tommy, Leo, and Hercules. All of them were unsuccessful. They failed. They were also supported or based in the will autonomy of the primates. And in the southern part of the continent, in Brazil and Argentina, there were also 3 different lawsuits, habeas corpus lawsuits, that on the contrary were successful, were the cases of the primates Suiza, Sandra, and Cecilia. In contrast with the non-human rights project lawsuits, these Southern America lawsuits were based on the need to protect the interest of the primates, not on their autonomy of will. What can we then say in conclusion when we look to all these possible strategies that constitutional law is trying to explore all over the world? We have deducted 4 conclusions. The first one is that anthropocentrism and speciesism still shapes the whole legal system. That is something that we cannot take out of our sight. Because of this, we think that it is truly difficult to build a citizenship theory, an animal citizenship theory, on a legal basis, because the core legal meaning of citizenship theory has developed from the beginning around empowering, that is, around the will of autonomy, or the autonomy of will. That is what failed in the habeas corpus lawsuits in New York, and not around protecting interests. Around protecting interests has developed the concepts such as welfare state, but not the concept of political citizenship. Political citizenship has evolved in these 250 years approximately around the autonomy of individuals, and not around protecting interests. So it could be difficult to ground animal fundamental rights on citizenship, on their citizenship, unless we change the meaning, the legal meaning of citizenship. Consequently, in our opinion, we need to grant legal personhood to animals. That is the most important movement we have to make in this regard, to switch from pure moral personhood to legal personhood. And maybe then, in a near future, we can give a further step and grant constitutional rights. But first of all, we need legal personhood. And again, in our opinion, the most realistic way to achieve this goal is to focus on indirect constitutional protection in those countries in which it could not be possible to amend and change the constitution to establish animal protection as a state goal yet, and in those in which it has already happened, to focus on this direct constitutional protection, to use it as a way to sustain and background the legal establishment of animal legal personhood, so that we can consider animals victims of crimes, so we can consider animals capable of standing before courts when properly represented by humans, etc., etc. Something that not happened, as you all know, in most of the legal systems yet. So in our opinion, we have to move slowly on solid terrain, step by step, and not trying to run too quickly or too fast, because maybe the outcome is not the desirable. Maybe we are right, maybe we are wrong. That is something we leave up to you. So thank you very much for your attention.
Thank you very much, Benito and Nuria, for this fascinating presentation on the rights of animals under constitutional law. I've personally learned a lot here, and I really enjoyed all the pictures of the ravens that you've included in your slides. We're now moving to our last presentation in this workshop, and it's a presentation delivered by Mihnea Tanasescu, who is a research fellow of the Research Foundation Flanders and is based at the Free University of Brussels in Belgium. Mihnea works in the multidisciplinary field of political ecology. His work has focused on the rights of nature, conceptions of political representation, as well as the politics of nature conservation. He is currently working on a book on the concept of mutualism, as well as a general introduction to the theory and practice of rights for nature. Today we have the pleasure of finding out more about Mihnea's work in his presentation entitled, "Who Represents the Rights of Nature?"
Thank you, Raffael, for this kind introduction and for hosting and organizing this really interesting, timely and necessary conversation. So today I want to talk about, indeed, who represents the rights of nature. It is no exaggeration to say that we are living through a new generation of rights expansions. It is ironic, or perhaps deeply related, that this expansion comes at the time of the greatest upheaval in human ecological relations. Worlds around us are increasingly disintegrating, and new forms of cohabitation have to be sought. Whether the paradigm of rights is apt for the job that it is charged with remains to be seen, but there is little doubt that it is forming an increasingly big part of the conversation. In my comments today, I want to focus particularly on the rights of nature, as this formulation has gained a tremendous amount of ground lately, both in scholarly and practical terms. Scholarship on the topic, of which I, as well as my colleagues, are part of, has never been more vibrant, while cases have continued to expand at a rate that even ardent proponents would not have expected. What is most exciting about this for me is how what used to seem like a sole paradigm, the rights of nature, is being multiplied and expanded to incorporate quite different practices as well as quite different conceptions. And I think that one way to show and to think about the increasing multiplicity of rights for nature is by focusing on who the representatives of a nature with rights might be. So here I want to do that by contrasting two different ways of understanding the problem of representation. Now, my background is in philosophy, and as befits analysis rooted in philosophy, I cannot plunge straight into the subject. First, I need to do a little detour through why the problem of representation is an apt way of engaging the rights of nature. A good place to start is the word itself. To represent means simply to make present again. It is therefore an operation of bringing into view something that has fallen out of view, but the implication is also that there is a mode of paying attention that would have acknowledged the subject of representation. That is to say that presenting again always implies that what is presented already existed, preceded its own representation. The effort to represent then is like the wielding of attention like a torch. Through representation, we beam into something that was there, but previously ignored. As the other talks have also developed, in the Western canon of legal as well as political theory, natural entities have been famously underrepresented. That is to say, legal and political attention has not been consistently wielded in order to bring natural processes and/or entities into relevant kinds of presence. This making present again is just one layer of the idea of representation. The other important one, in the cases that interest us, is the structural necessity of speaking for previously unrepresented natural entities. My claim is not the familiar and quite hackneyed one that goes something like, nature can't speak for itself, hence it needs representatives. No, I think that natural processes and many different kinds of animals have specific ways of communicating that are absolutely intelligible across species. But the point is that in order to count politically and legally, you need to speak in a particular kind of way. This is what raises the necessity for representation when we are considering nature or animals. It is not that they do not speak in absolute terms, but rather that they need to speak in legal and political speech, as it were, in order to count within those particular processes. So however it is that we plan on incorporating other than human beings within the polis, the concept and practice of representation is necessarily involved. So when thinking about the rights of nature, my claim is that the idea of rights becomes an operation of representation. To grant rights to other than human entities is necessarily to make them present within a process where they rely on human interpreters to ensure their presence. This, by the way, holds for non-human entities like trusts and corporations as well. The relevant question then becomes, who represents a nature with rights? And we are then back at the beginning. Now that I have tried to establish a little bit the idea of representation is necessary for understanding what rights for nature are doing, I want to move on to describing two different ways in which representation is conceived of in different cases of rights for nature. I want to focus on the two most prominent international cases so far, namely the Constitution of Ecuador and the legal personality arrangements for Te Urewera and the Wanganui River that Cormac also mentioned. I will contrast a way of understanding representation as the domain of potentially everyone with another way in which representatives are highly specific to a particular place. Through this discussion, I want to show that how we think about representation has everything to do with how rights of nature will end up looking in practice. So let's start with Ecuador. I will not recount the whole history that I'm sure a lot of you are familiar with, and a lot has already been said about the Ecuadorian case, but I will just point the relevant moments for the concept of representation. In 2008, Ecuador passed the first constitution in the world to incorporate rights for nature in what became a deservedly famous document. There, it is nature as such that received the right to respect, restoration, and preservation of its natural cycles. What these mean, how they are applied, whether they are consistent with other constitutional provisions, are all very interesting questions that I cannot get into right now. Instead, I want to zoom in on who, according to this document, is entitled to representing the rights of nature. There are two layers to this. First, the fact that the rights of nature are enshrined in the Constitution in itself ensures wide standing. In other words, nature has constitutional rights, and this means that a wide variety of potential representatives can claim standing to defend its rights, precisely because they are constitutional. But the document is also explicit in granting legal standing to everyone, irrespective of relationship with any particular environment or even of citizenship. In theory, I could sue to protect nature's rights in Ecuador. This view of representation is the broadest possible one, and it is correlated with a view of nature that is also all-encompassing. Nature in the Ecuadorian constitution is the definition of the all-encompassing, holistic global sphere. It is purposefully set up to be potentially applicable to nature outside of Ecuador, similar to how human rights are extraterritorial in that they attach to a universal subject. So in the constitutional case of Ecuador, we have a series of conceptions that function to mutually reinforce one another. First, the constitution as a setting for the rights of nature already gives wide standing. The doctrine of standing is then specifically extended to anyone that wishes to represent nature's rights. And third, the concept of nature is understood in its most abstract sense, in ways that I have argued before are analogous to how the human of human rights is understood. And in this, there are also important differences with specific animals and animal rights. In practice, the Ecuadorian law has had mixed results, as one might expect when analyzing it from the point of view of representation. There is nothing in the Constitution to prohibit cynical use of nature's rights, because anyone can be taken as a legitimate spokesperson. And so, the Ecuadorian state, notable for its extractivism and internal colonialism, has been very keen on using nature's rights in ways that help its broader projects. The point is that, however tempting it may be to think of these as abuses of the rights of nature, the particular concept of representation baked into the Ecuadorian conception makes this eminently possible. I want to now briefly turn to one particular New Zealand case. The first legal personality arrangement in New Zealand dates from 2014, when Te Urewera, the ancestral home of Tūhoe, a Maori group on the North Island in Aotearoa, New Zealand, became a legal entity. The Wanganui River case is much better known. I'm sure that all of you know something about it, though it came 3 years later. And this continues to be a curiosity for me why the Wanganui is much more famous than Te Urewera, though Te Urewera came before. And I suspect it might have something to do with rivers that are also in the title of the webinar. But here I want to focus mostly on Te Urewera for two reasons. It is similar in crucial respects to the Wanganui settlement, so what I'm saying about it can also be to some extent applied to the Wanganui, and it offers the starkest contrast with the Ecuadorian case I briefly presented. But in order to be able to adequately discuss this case, I need to set a bit of context, and I will do a bit more than I did for Ecuador, partly because it is relatively less known. Te Urewera is one of the most remote parts of New Zealand's North Island, so much so that it was the last part of the country to be settled by European colonists in the 19th century. Within the wider history of Maori-European encounters, this region and its people, Tūhoe, have developed particularly conflictual relationships with Europeans. The first contact between Europeans and Maori dates from 1769, when the Endeavour, captained by James Cook, landed on the eastern shores of the North Island. 70 years and many missionaries and settlers later, in 1840, the British Crown and many, though not all, Maori chiefs signed the Treaty of Waitangi, the most important document in New Zealand's history. After the signing in the town of Waitangi, the treaty was taken across the island for additional signatures. Tūhoe in Te Urewera never signed, though this does not mean that they or their land did not come under the effects of this monumental event. There are two versions of the Treaty of Waitangi, a Maori and an English one. The chiefs signed Te Tiriti, the Maori version, while the British signed and most importantly implemented the English version. The two linguistic versions of the treaty are quite different from each other. The difference pivots on the translation of key Maori concepts into English and vice versa. To make a very long story short, the Crown has interpreted its version of the treaty as signifying that Maori chiefs had ceded sovereignty when signing the treaty, while Maori chiefs, according to their own version of the treaty, never did such a thing. Recent scholarship and recent judicial decisions tend to agree with the Maori version of events. Starting in the 1860s, a period of aggressive colonization began, with land purchases and confiscations greatly expanding the settler populations. Demography shifted from Maori majority to Maori minority in little more than 50 years. The Maori population dropped from around 200,000 in 1840 to only 40,000 in 1900. Te Urewera remained the last bastion of Maori tikanga, which means ways or laws or traditions or customs. And it was only in 1865 that the crown confiscated much of Tuhoi's most productive land. Between 1865 and 1871, there was a war between the crown and Tuhoi in Te Urewera, which, by the crown's own admission, devastated Maori groups through starvation, executions, and further appropriation of lands. Tuhoi have been consistent throughout this history in asking for mana motuhake, a term very close in meaning to another Maori concept, namely tino rangatiratanga, both of which approximate the English concepts of authority and sovereignty. As Rawinia Higgins, a New Zealand scholar, explains, distinctions between mana motuhake and tino rangatiratanga are contextual rather than categorical, but while they have much in common, mana motuhake more strongly emphasizes independence from state and crown and implies a measure of defiance. Throughout the 19th century, this defiance was expressed also through the sheltering of other Maori people that were fleeing persecution elsewhere. Fast forwarding through a complex history, in 1954, Te Urewera became a national park, which seemed to seal its fate as a settler fantasy of nature forever stolen from within an intricate human nature genealogy. The first major break in what seemed to be a sealed fate came in 1975, when the Waitangi Tribunal was inaugurated as a commission of inquiry tasked with looking into Maori claims that laws, policies, acts, or omissions of the Crown are or were inconsistent with the principles of the Treaty of Waitangi. In 1985, the jurisdiction of the tribunal was extended back to 1840, the moment of the signing of the founding treaty. This decision set in motion the contemporary era of claims settlement, because Maori groups finally had a framework through which to contest the ways in which the Crown had historically appropriated their lands. So this is the legal history and the history that we need to understand in order to understand what happened in 2014. The grant of legal personality to diverse landscapes in New Zealand has to be understood in this post-1985 context of treaty settlements. Tuhoi began negotiating with the government in 2005. For Tuhoi, the return of Te Urewera under their authority was non-negotiable, although it was far from clear at the beginning what this return might look like. The government, in turn, feared that negotiating Te Urewera would lead to Tuhoi creating a separate nation and closing borders and access to Te Urewera, which was still a national park at the time. To make a long and complicated history short, the return of Te Urewera under the authority of Tuhoi took a form that nobody had anticipated at the beginning. Te Urewera became a legal entity. Now, I took the time to recount this important context because it has everything to do with the issue of representation. Here, unlike in the case of Ecuador, we are speaking about Te Urewera, not nature as such. It is a particular place with a very particular history and a very particular web of relations, weaved together with particular people. So already at the level of the represented, that is the subject of representation, this is very different. At the level of the representatives, those entitled to speak for the legal entity, we are also on radically different terrain. The Urewera Act 2014 creates a board formed of a majority Tuhoi and a minority Crown representatives that is the only entity authorized to speak on behalf of Te Urewera. In other words, the grant of legal personality in this case uses the mechanism of representation in a very specific way, and does so in order to intervene decisively in a historical dispute over who has authority to govern in this specific land. In other words, the issue of representation here is revealed to be intimately tied to the issue of authority. To have the right to represent is also to have the authority to do so. One last thing I want to point out about this case. Te Urewera did not receive any particular rights. It was only formatted as a legal entity. This was in order to solve the property dilemma. Who owns Te Urewera? The legal entity solution basically says that Te Urewera owns itself. But this self-ownership makes the issue of representation even more important, because it is only those authorized to speak on behalf of the self-owning entity that are able to intervene in its governance. Of course, there's much more to say about this fascinating case, and in practical terms, it is too early to tell what the effect of this has been. But theoretically speaking, I would expect this particular representative arrangement to be more resistant to abuse, simply because it does not incorporate the possibility of diverse representatives. We may talk about how one justifies the setting of representative relations in law once and for all, but what I wanted to do here is simply to point out how taking the concept of representation seriously helps us navigate differences and similarities between different cases of rights for nature. It also helps illuminate the political core of legal innovation. In this sense, Tehuelhuela is as constitutional as Ecuador, though the law is not in the actual constitution. It does, however, modify the political and legal terrain to such an extent that it effectively constitutes a new order, which is, after all, the meaning of constitutionalism. To sum up, who represents the rights of nature varies considerably among the extant cases, and we could go through the other cases in a similar fashion, and will in all likelihood continue to vary among future ones. The point is to be cognizant of the importance of representation because it is only through it that nature's rights connect to processes of actual change. It then also becomes important to be careful to not assume that some groups will be representatives of nature's rights because of intrinsic connections we may suppose they have with nature. The law, in one way or another, specifies representative arrangements, and it is there that much innovation needs to happen in order to fully use the political potential of this legal innovation. So, if you are considering granting rights to a particular environment, it may be useful to pause and think about the kinds of representative relationships that would best serve the purposes you are trying to reach through the concept of rights. Perhaps the starkest preliminary conclusion that can be drawn from this discussion of representation is that the rights of nature do not come with embedded environmental results. Instead, everything depends on future representative efforts on behalf of the legal personalities inaugurated through rights. And these efforts are absolutely tied to the way in which laws are written and to the purposes that they aim to codify. To return to the case of Tehuelhuela, the main purpose there was to avoid the issue of ownership by inventing the mechanism of self-ownership and to return governance authority to Tuhoe. That is what the Tehuelhuela Act achieved. Whether it also means that the health of the forest would benefit remains to be seen, as it is entirely dependent on how the board chooses to represent Tehuelhuela, the legal entity. Similarly, the Constitutional Assembly in Ecuador chose to enshrine the rights of nature for a variety of reasons, but by leaving the issue of representation wide open, they introduced further uncertainty vis-à-vis potential environmental benefits. Finally, I want to point out the obvious. To say that the rights of nature do not come with embedded environmental results is not to say that they are deficient on that count. It is simply to point out that it is the representation of nature with rights that in the final analysis counts. We cannot go around the problem of representation because we cannot escape the fundamentally political nature of the law itself. I think I'm going to stop there to leave more time for discussion, and I hope to have added something of value to our discussion of the meaning and practice of rights for nature. So thank you very much for your attention, and I look forward to our continued dialogue.